Good evening, everyone. Selamat malam. Okay, welcome to the eighth installment of the Social Work International Lecture Series, organized by the Indonesian National Association of Independent Social Workers in collaboration with the national universities and institutions. I am Disya Marianti, and I'm honored to serve as the host for today's Social Work International Lecture Series. All right, before we begin, allow me to extend a warm welcome to our esteemed guests and participants. We have Dr. David Gillis as our speaker here, and also Ibu Johanna Deborah Imelda as our moderator. Also, a warmest welcome to the representatives of the Ministry of Social Affairs of Indonesia and the Indonesian National Council of Social Welfare. Welcome, Dr. Puji Pujiono, the President of the Indonesian Independent Association of Social Workers, along with the specialized social worker associations and provincial chapters. Welcome, Bapak Muhammad Ali Ekwatora, Bapak Tora, the chairperson of the Indonesian Association of Social Workers in Justice System and Correctional, or APSOS-PECSI, together with social workers and representatives of the association. And also, welcome to our collaborating universities, Muhammadiyah Jakarta University, the Islamic State University of Jakarta, Binawan University, University of Indonesia, and Pajajaran University. Lastly, welcome to our distinguished participants, including social workers, lecturers, and students who are joining us today. We are truly honored by your presence and grateful for your continued support in advancing the field of social work in Indonesia. Ladies and gentlemen, the Social Work International Lecture Series is a recurring forum that aims to foster global knowledge exchange and the development of social work practice in Indonesia. This initiative is designed to be a learning platform that bridges global insights with local practice and supports Indonesian social workers in deepening their understanding of social work practice. This month's lecture, entitled From Punishment to Restoration, Criminal Justice Paradigmatic Transformation, it is aligns with Indonesia's significant shift to a new criminal justice paradigm with the implementation of the National Criminal Penal Code in 2026. This new approach will prioritize human rights and human treatment, favoring restorative justice, diversion, non-incarceration, and when necessary, rehabilitation and reintegration following imprisonment. The existing prison social service system will expand its involvement of social workers and broaden its focus on psychosocial support, protection, and the fulfillment of human rights, particularly for the vulnerable group. And during the recent World Social Work Day 2025, Indonesian social workers established the Indonesian Association of Justice System and Correctional Social Workers with ongoing development of its practice framework. So it is crucial that this framework be informed by an expert who can offer insights into the paradigmatic shift and its dynamic in other countries for social work development in Indonesia. Our featured speakers, Dr. David Gillis, a leading authority on justice and correction reform, democratic development, and fragile states, will share his insights on justice and correction reform from international perspective that we believe will be useful in strengthening the vision and competency of Indonesian social workers, particularly in justice, governance, and human rights. All right, ladies and gentlemen, now to officially open the session, we are honored to hear from Dr. Puji Pujiono, the President of the Indonesian Independent Association of Professional Social Workers or IPSPI, who will deliver the opening remarks. Pak Puji, the floor is yours.
Thank you, Risha. Good evening. Assalamualaikum warahmatullahi wabarakatuh. It's really my pleasure
Waalaikumsalam
to have been assigned by the manager of the International Lecture Series, Disha Marianti, who has been handling this brilliantly. Representative of Ministry of Social Affairs, representative of the National Council of Social Welfare, as well as premier universities who have been joining us and in collaboration and organizing this monthly international lecture series. This afternoon, I had a meeting with the National Association of Social Work Education, and everybody resounded and agreed that this session is an important one, not the least to connect us, the practitioners and the academic communities. At the same time, this is also a platform, as Tisha said, to update ourselves of the new paradigms, to reflect to practices in different places, and to learn from one another. Tisha, one thing that I learned very quickly, though, it seems like when we do the session in the evening, there are more people joining, right? When we do it during working hours, it seems like 30, 50, but now 75 online. And I assume that the YouTube will have more turn up as well. Ladies and gentlemen, as Disha was saying, that correctional is one of the traditional field of social work for many, many years, since the beginning. But in the case of Indonesia, historically speaking, this discipline happened to be shifted somewhere else, namely to the Ministry of Law and Human Rights in the past. But that being said, Professor Tora will tell you more about this trajectory of the discipline. What I will highlight very quickly is the fact that next year, there's going to be a new penal code implementation that will warrant much broader social work practice. And I personally do not believe that the existing practice now has it enough in its end to respond to that change. And therefore, I was very, very excited a couple months back with my colleague Agustus Fajar, who is the Secretary General of the association, that we discussed intensely of how to facilitate social workers to establish a new association, the Association of Correctional Social Workers. And as we discussed that, the topic has widened, that it does not only cover correctional, but in fact, it needs to cover the broader remit of the social, the justice system. Not the least that there are 8 legislations in Indonesia that explicitly mention social work as a profession that are required to extend their expertise to manage cases. The very particular one being the juvenile criminal system that explicitly state, for example, that children are not to be brought to court without the accompaniment by social workers. That any decision on children's criminal system, the justice system, will require the so-called social report by social workers. So this highlights the important role of social workers in the justice system and correctional. And in that regard, I'm very, very, very privileged to have Dr. David Gillis, a personal friend that I esteem, my distinguished colleague, whom I met in Thailand a couple months back. And as I was thinking about the social work and justice system, this distinguished gentleman across my table was saying, I'm a social worker. I work in justice system in the past. So I thought, this is really a godsend. So I requested David if he would like to speak for us, and he gracefully granted my wish, and there he is. And I assume that Professor Tora and Debbie, that this could be the beginning of a good friendship between us and Dr. Gillis from now onward, that hopefully, and I'm sure he will, also be happy to speak more in your classes, in your seminars. And I really hope that not too long from now, Dr. Gillis will actually visit Jakarta and meet us from Canada, where he is now. So with that, David, welcome. Thank you very much. And I am so very grateful to Debbie, who stepped in as a moderator today and having University of Indonesia in the fold. Disha, with that, I wish everyone, 85 of them now, and the number is climbing up. Welcome. I hope you enjoy the session that we learned together, and I'm looking forward to the discussion much later. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Yeah, thank you, Pak Puji, for the remarks. Yeah, it set a strong foundation for today's discussion, Pak. All right. Next, we are also honored to welcome Associate Professor Muhammad Ali Ekwatora, Bapak Tora, the chairperson of the Indonesian Association of Social Workers in the Justice System and Correctional, who will present an overview of the Indonesian context of the justice and correctional systems. And also, he will introduce the association profile and highlight the relevance of this month's lecture theme and the objectives of today's session. Pak Tora, the floor is yours. Okay, Pak Tora, you are still on mute.
Thank you, Disha. Good evening, my dear colleague. I hope you are well and a good spirit. Thank you for Dr. Fujiono, President of IPSPI. You remarkable often also welcome Dr. David Gilles. You present mean so much to us. Yeah, also, I would like to say my gratitude to every person that contribute. So this event may occur. I wish that we are doing right now could benefit to our world. For the press, I want to talk about how to overview of Indonesia contact justice system and correctional. Indonesia justice system is a complex root in blend of customary, adat, law, Islamic law, and Sharia, and Dutch colonial law reflected the country diverse cultural and historical background. The judiciary in independent and co with executive and legislative branch with the Supreme Court, Mahkamah Agung, and the Constitutional Court, Mahkamah Konstitusi EDPEC. Court structure, the court system is organized into 4 pillars: General Court, Religious Code, State Administrative Code, and Military Code. It's follow at 3-level hierarchy. First level court, peradilan tingkat pertama, lokal in Mangfius, municipality, multi-speciality with original jurisdiction over case. And then second level courts, peradilan tingkat banding, based in provincial capital, handing a appeal from first level court. And then 3-level court, peradilan tingkat kasasi. The Supreme Court in Jakarta serves as the final appellate court and has original jurisdiction in certain case. The legal system is a primarily civil law base, employed by Roman Dutch law, but also incorporates Adat and Islamic law, particularly in family and religious matter. The judiciary face challenges include corruption, inefficiency, and result of constraint, which affect the delivery of justice. Correctional system in Indonesia, correctional is a subsystem of criminal justice system that enforce law and the field and treatment of prison, children, and inmates. The correctional system is a system regarding the direction and boundary as well as the method of implementation the correctional function in integrated manner. Signed, the enactment of the Correction Age Law number 22 2022 years. The system emphasizes social reintegration and rehabilitation of inmates, aiming to transform offender into responsible member of society rather than the focus solely on punishment. Key future. Imprisonment remains the most common form of criminal punishment, but there is a growth focus on education and rehabilitation with correctional institution. Government regulation number 1999 at 2012 years amend earlier regulation to impose stricter condition on remission, parole, and assimilation for offender of extraordinary crime such as terrorism, corruption, and narcotic offenses. This has led to complication in inmate right to parole and remission, overcrowding, and inconsistent application of regulation. The correctional system is challenged by overcrowding, procedural complexity, and occasional human rights violation with prison. Legal dualism and challenge. The correctional system reflects Indonesia legal dualism, where customary law and formal state law coexist, sometimes leading to inconsistent consistent in implementation. There is ongoing debate, advocacy for revising regulation of 1999 at 2012 to better align with rehabilitation goal and human rights standard. How the position of social worker in implementation of law number 1 of 2023 of the Penal Code KUHP. The law number 1 of 2023 of the Penal Code introduced fundamental change to Indonesia penal system. One of the which is the introduction of community service probation officer. In another country, we say the probation officer. Indonesia said pembimbing kemasyarakatan. Service penalty is an alternative to short-term imprisonment. This change directly affect the position of role social worker with the criminal justice system. Role of social worker under a new criminal or penal codes. And the first, assistance and rehabilitation. Community service penalty, kerja sosial. As regulation in Article 85 of Law number 1 of 2023 are intended not only as a form of punishment, but also as a means of rehabilitation and social reintegration for perpetrator of minor offense. Social worker play a key role in assisting offender during the community service, aiding in recovery and assuring adequate social guidance to help them positively reintegrate into society. And the second, social report preparation. In some cases, professional social work are involved in preparing social report, which include the offender background, family condition, and other relevant social factor. The report can serve as a consideration for judges, although they are not legally mandatory in adult criminal case, unlike juvenile case. The third, collaboration with community counselor. Jadi for next year, social work must be collaboration with pembimbing kemasyarakatan. Law number 1 of the 2023 also emphasizes the role of community counselor, PK, provision officer in another country, is in conducting in community research, mentoring, guidance, and supervision of client, both adult and juvenile, in several professions. Professional social work are mentioned as collaborating with community counselor, especially in case involve minor or offender needing a social approach, pendekatan sosial. What the legal standing and challenge? Strong legal foundation. With more detailed provision in the new criminal code or penal code, the formal recognition of social worker in the criminal justice system is strengthened, particularly as part of implementing community service and supervisory penalty. 2023 of the Penal Code, KUHP. The Penal Code Implementation challenge. Social worker face challenge at such as infrastructure rightness, interagency coordination, and the need for clear standard operation procedure to ensure community service penalty are generally effective rather than merely procedural. Additionally, social worker must balance the interests of offender, victim, and society in the rehabilitation and reintegration process. What the conclusion? The enforcement of law number 1 of 2023 penal code strengthened two rule of social work as a vital part of more human and rehabilitation penal system. Social workers are not only involved assisting offender, but also ensuring that community service penalty fulfill their intended purpose, recovery, reintegration, and reduction recidivism. Collaboration with community counselor are relevant agency in key success to is key to successfully implementation community service penalty in Indonesia. Change phase of social worker implementation in implementation law number 1 of 2023. The implementation of law number 1 of 2023 presents several challenges for social worker, particularly in applying community service as an alternative to imprisonment. These include infrastructure and resource readiness. How to implement it? Community service require adequate infrastructure, human resource, facilitated budgeting. Without the support, the implementation may become ineffective and merely procedural. Limited results. A lack of facility of competent social worker as well as insufficient logistical support hinder delivery of effective and sustainable social intervention. Slow legal process and bureaucracy. Delay in the judicial system and complex bureaucratic procedure make it difficult for social worker to provide time service. Case complexity and family condition. Many cases, such as those involved neglected children or minor offender, stem from family with complex socioeconomic condition, complicating proper assessment and intervention. Number 5, lack of public awareness and support. Low public awareness of the importance in social protection and restorative justice often lead to lack of social support and even negative stigma toward social work client. The stigma and distrust hinder the reintegration process. 6, unclear technical rule and guideline. The absence of clear implementation rule and technical guideline for community service penalty make it difficult for social work to carry out their duty consciously and may lead to inconsistent interpretation in the field. And 7, legal system adaptation. Integrated community service concept based on common law principle into Indonesia civil law system require insignificant adjustment in the both criminal law and codes procedure. The adaptation process may cause confusion in practice. Social work are expected to continue to improve their competency, strengthen cross-sector coordination, and advocation for clearer implementation rule to ensure the rehabilitative and human penal goal are a safe optimalisasi. Thank you for welcome remark from Ami.
Alright. Thank you very much, Pak Tora, for your remarks and the overview of the condition of justice system and the challenge that social work face in the justice system and correctional. And once again, congratulations for the establishment of the Indonesian Association of Social Workers in Justice System and Correctional. All right, ladies and gentlemen, with that, we now officially open today's session, and we now move to the main part of our program. We will continue to the main lecture session. And it is my pleasure to invite our moderator, Dr. Johanna Deborah Imelda, also known as Ibu Debbie. Hello, Ibu Debbie. Thank you very much for your support to the International Lecture Series program.
Thank you.
Yeah, thank you. So, ladies and gentlemen, Ibu Debbie is an associate professor at the Department of Social Welfare, Universitas Indonesia. She has a strong background in population studies, medical anthropology, and a PhD from the University of Amsterdam. Her work focuses on children, women, health, and she has collaborated internationally, including a postdoctoral project with Monash University, Malaysia. We are honored to have her guide today's session, and without further ado, I now hand over the session to Ibu Debbie. Ibu Debbie, the floor is yours.
Thank you, Mbak Disha. Good evening, ladies and gentlemen on Zoom meeting as well as on YouTube channel. On behalf of the organizing committee, I'm Johanna Deborah Imelda. It is both an honor and a privilege to extend a warm welcome to all of you. We are deeply honored by the presence of the esteemed representative from the Ministry of Social Affairs of Indonesia and the Indonesian National Council of Social Welfare. Thank you for joining us and for your continued support of social work advancement in our country. And special welcome as well to Dr. Puji Pujiono, the MSW, the President of the Indonesian Independent Association of Professional Social Worker. We call it in Indonesia IPSPI. Along with leaders of specialized social worker associations and provincial chapters, your presence truly enriches this event. And also we are privileged to welcome Associate Professor Muhammad Ali Equatora AKS MSI, Chairperson of Indonesian Association of Social Workers in Justice System and Correctional. In Bahasa, we call it APSOS-PECSI, and the dedicated social workers and representative from your association. Thank you for your tireless work and contribution. And also, we are privileged to have with us today an outstanding speaker, Dr. David Gillis, who will share his insights and experiences with us. To our respected academic partners from collaborating university, Muhammadiyah Jakarta University, the Islamic State University of Jakarta, Binawan University, and of course, Universitas Indonesia and Pajajaran University also. We thank you for your continued collaboration and commitment to excellence in social work education. Last but certainly not least, a warm welcome to all distinguished participants, including social workers, lecturers, students, Your enthusiasm, insights, and dedication are what make this meaningful. This event meaningful. Together, let us share, let us learn, and build stronger collaboration for the future of the social work in Indonesia. Once again, it is truly a pleasure for me to welcome all of you to today's seminar entitled From Punishment to Restoration, Criminal Justice Paradigmatic Transformation, which I believe will be one of the interesting topics in the 8th Social Work International Lecture Series. So after this, we have some more series, lecture series. For today, this seminar aims at first to provide insights into justice and correction reform from an international perspective. The second, the objective of this seminar, this lecture, is to support the development of Indonesian Association of Justice System and Correctional Social Workers. And the third objective is to broaden the vision and competency of Indonesian social workers, particularly in justice, governance, and human rights. Allow me to share with you a short bio of Dr. Gillis. Dr. Gillis is a retired Canadian civil servant with a background of international development. He has specialized in good governance, democracy, and human rights programming, including legal and judicial reform. He was Canada's head of aid during posting in Zimbabwe and Pakistan. Prior to emigrating to Canada, Dr. Gillis served a probation officer in United Kingdom. Based in London, magistrates court and were specialized in working with young offenders. Dr. Gillis holds a PhD in political science from McGill University, Montreal, and an MSc in applied social studies and a certificate qualification in social work from Oxford University. Wow. He's also an author or editor for 4 books, including Democracy and Foreign Policy in an Era of Uncertainty as a co-editor, which is published in Palgrave Macmillan in 2023. Okay, so before we begin, allow me to remind everyone for the rules. Yeah, I will remind everyone to kindly keep your microphone muted. Yeah, unless you are asking question, to minimize background noise. We also encourage you to actively participate during the Q&A session, as your question and perspectives will enrich our discussion. So feel free to share your thoughts in the chat box or during the Q&A session later, when you can engage with our speakers directly. Our speaker directly. We will prioritize the live verbal question followed by the selected written ones. So you can also write down in the chat box. This session is conducted in English and will be recorded for future reference, but you can always ask question in Bahasa Indonesia, then we will translate it for you. Okay, without further, let us proceed to this session. Please join me giving a warm welcome to Dr. Gillis. So welcome, Dr. David, and the time is yours.
Thank you, Dr. Ibu Debbie. Wonderful to be here with such a distinguished group of government, university, and of course, students, social work practitioners. I hope we'll be speaking a common language as we all share in both the opportunities and challenges presented by the new penal code, which I understand will start being implemented next year. It clearly, as we'll discover in some remarks I'd like to share with you on a comparative context, Indonesia will presumably face some of the same opportunities and some of the same challenges that other societies have either been through or continue to navigate, particularly balancing the demands of society for punishment and reparation with the principles of rehabilitation and reintegration. So I wanted to do a couple of things. I've got about half an hour this evening. By the way, it's here. It's a lovely spring morning here in Canada. We've just had an election, so there's a certain sense of excitement and newness and opportunity also where I'm sitting in my part of the world. I'd like to do a couple of things. Firstly, as I mentioned, share with you from a comparative context what one or two other jurisdictions have been through on this road from, shall we say, a more punitive prison-based approach to a set of alternatives to custody. And also at the same time, obviously, as a practicing probation officer earlier in my career in the UK, affirm the promise and potential of non-custodial approaches to criminal justice. But I want at the same time, and I believe Professor Toro in a sense alluded to this in his opening remarks, underscore the vulnerability of criminal justice systems to shifts and changes in politics and public opinion, and to the challenges of poor uptake, weak implementation, pressures on resources. Indonesia will have its own set of challenges, but societies are not unique in that respect. Even so-called established democracies in Europe have a challenge in this area too. So let me jump into it and just say at the outset, I think, as Dr. Puji has said, there's growing awareness that, growing global awareness that custody is not always the most effective way in meeting all the various criminal justice considerations and objectives. And just to remind ourselves, these include, importantly, public safety, punishment, deterrence, reducing reoffending, and then also rehabilitation and reintegration of the offender in society. Yeah, but balancing all these complex objectives, the issue of accountability to victims and society must be high in the mind of most judges as they pass sentence. So while I'm a little bit skeptical about the idea of a global paradigm shift, the important fact is there is a paradigm shift in the conversation and enabling legislation in Indonesia, which is very, very exciting. A global paradigm shift towards non-custodial ways of dealing with criminality. I do believe there's increased global momentum, certainly, to exploring non-custodial options. Where does this interest come from? Well, I think there are a number of considerations here. One is very practical, dollars and cents, pounds, British pounds, and that's the issue of rising costs. In the UK, for example, where I practiced many years ago, it costs these days an average of about 47,000 British pounds per year per prisoner, with a prison population of 88,000. That's about US dollars, about 60,000 a year per prisoner. For probation, it can be up to 10 times cheaper for the state to in a sense, manage the offender in a social context rather than in prison. So that's one, rising costs. There's also a raft of evidence, solid research over decades, which has underscored the limited impact of custody, and in particular of longer sentences on two things, on deterrence and on recidivism or reoffending, as we call it. Thirdly, there's growing interest in ensuring and understanding that victims have a voice too, and that they have been impacted by crime. Bringing the victim in is another issue. Finally, well, there's a couple of other points. There's, unfortunately, in many jurisdictions, high rates of reoffending. Just to give you 3 examples. In the USA, up to 60% of prisoners released from prison reoffend within 3 years. In the UK, it's hovered at about 50% reoffending rate for many, many years. In more, shall we say, quote unquote, progressive jurisdictions like Norway, it's as low as 20% reoffending in 2 years. Nevertheless, these are fairly high rates of reoffending. And then, of course, there's all the evidence and the palpable evidence that social workers and probation officers see on a day-to-day basis, either in prisons or working with prisoners' families, of the negative impacts of custody on individuals, on the possibilities of family life and parenting, and on the fabric of communities. And so all of that has shifted the policy conversation in the direction of rehabilitation. Professor Tora alluded to many of the issues around the problems of implementation. Let me also just underscore that in many jurisdictions, of course, judges must take account of the most serious and violent crimes for which punishment and for which prison may be the only possibility. But the fact of the matter is that in many jurisdictions, I do not know the circumstances in Indonesia, but in many jurisdictions, large numbers of prisoners are in custody for relatively minor offenses. Prison populations are also not infrequently have many marginalized groups in them, disproportionate numbers. In Canada, that means indigenous populations, the so-called First Nations. In America, it's often Black Americans. Many prisoners we know grew up in poverty and have deeply troubled family backgrounds, or indeed no families to speak of. Some have very low educational attainment. They may not read, they may not write. And we know that mental health and substance abuse issues are common. So it was very interesting to listen to some of the specifics of the new penal code, mapping out the kinds of non-custodial arrangements that are coming in Indonesia. But let me just say, and this is really a back of an envelope list that reflects in some sense the UK experience. We can talk about the kinds of alternatives for supervision in the community rather than custody. What do we have? In the UK, we've got probation, as you will have. We've got community service orders. We have youth diversion programs. These are often initiated by the police. They're community-based solutions for minor infractions and offenses. We'll talk more about that. We have, there are things like electronic monitoring. You can be confined to a designated place. There is, of course, parole. In Britain, many sentences actually the prisoner ends up serving half the sentence. They are then reviewed. Their circumstances are judged. Have you made some progress? If so, they're released, often after serving 50% of their sentence. And then, of course, there are things like fines, suspended sentence. You get a prison sentence, but it's suspended for 2 years on good behavior in the community. And then there are conditional sentences. You can be released into the community as long as you agree to, shall we say, join a substance abuse program. There's been experimentation, as you all know, with restorative justice. Again, this is police or court mandated diversion, brings together the victim and the offender, and in some cases, the community, to address harm and to promote reconciliation. We can talk more about that perhaps in the Q&A. And for those, and Britain has really changed. I was in one of His Majesty's prisons just last month. And in my day, the opportunities for rehabilitation in prisons themselves was quite limited. There was a lot of overcrowding, we'll come to that. But today, the particular prisoner I saw on several occasions, he is doing an English language course. He has daily work provided. He has a social worker he meets for mental health counseling, and he takes part in some group work as well. So there are things like vocational training, education courses, mental health and social work counseling, and there are substance abuse programs. A lot can happen on rehabilitation within the prison prior to release. Okay. Let me turn to something now to do more with policy and to get back to some of the points that were raised earlier in the opening remarks about the challenges of implementation. Again, I don't know the circumstances in Indonesia, but the fact is some countries, they don't necessarily always have a clear or a durable model of addressing crime. Approaches to sentencing can change, shifting with the political winds. Governments, understandably, are highly reactive to public opinion and to mass media. Unfortunately, some of that mass media and public opinion can be somewhat misinformed. Democracies with strong traditions of civil liberties and commitments to international human rights are also prone to periodic, quote unquote, law and order campaigns, wars on drugs, tough on crime, policing and sentencing regimes. All politicians, very understandably, have a natural preoccupation with public safety. That means that legislation is the necessary, vital, and most important part to launch possible approaches to non-custodial criminal justice. But that, in a sense, is only the first step. Sustained political will, public engagement, sustained public policy focus, all of those are necessary ingredients. An uptake can be slow in the absence of systematic education and advocacy for judges, for police, for prosecutors, for publics, and of course for ourselves, social workers, either working in a Ministry of Social Affairs or as part of the correctional and prison systems. Beyond that, of course, we need, as has been pointed out in the opening remarks, technical regulations. We need institutions and we need infrastructure. In my day, in my area, there were things like halfway houses to help an offender on release reintegrate to society. He has no family connections necessarily. He has a place to stay. He has professionals working around him. He has the possibility of slowly and gradually reintegrating himself, herself back into the community. Finally, evidence. Systematic and independent research is also vital to establish an evidence base showing what works and what does not in non-custodial sentencing options. All right, so if you'll allow me, I will shift now to some examples from one other jurisdiction that I happen to know a little bit about, and that's the United Kingdom. And yes, of course, the UK is a particular society at a particular point in its development, and Indonesia is a very separate, geographically separate and distinct cultural situation with its own legal history and own complexities. So I don't want to overstate the comparison, but I do think there are a few things that you might find interesting in the UK example. I'd like to talk about a couple of trends that happened over the last, shall we say, 20, 30 years in the UK. One is the gradual shift towards longer sentences, unfortunately, and a growing prison population. And part two, in a more recent government, there was an effort to privatize a portion of probation service delivery, particularly around non-custodial options. So I'd like to come to those two things. Put very briefly, looking at the UK, it's got a sort of a mixed approach to sentencing. Most sentences passed in the UK are non-custodial. As many as 90% in 2019 were non-custodial sentences. And in fact, the UK was one of the earliest European countries to experiment with non-custodial options. It has maybe the most wide range of non-custodial options of any European country, maybe it's more than in the US. Again, I cannot speak for Asia. Having said that, all of that non-custodial range of options, which has been there, by the way, since the 1970s, they've been experimenting with this. The UK's also had periods where incarceration rates have spiked, have risen sharply, and we are in one such moment. Currently, the UK has one of the highest imprisonment rates in Europe. And as I mentioned, with an average cost of about, shall we say, US 60,000 per year per prisoner. England and Wales, for which stats are collected separately, has the very highest rates in Europe. When I was practicing under Margaret Thatcher's government, it was also quite high. Today, the population of prisons is approximately 88,000, with an occupancy rate of 99%. In my day, it was in the low 40,000s. Even then, there was widespread concern that the prisons were overcrowded. I would frequently go to some of the old Victorian prisons and see 2 and 3 prisoners waiting for trial. They hadn't even been convicted in the same cell, designed for one. Less than 2 in 5 prisoners that were given prison sentences in 2022 were given sentences for violent crimes. 2/3 of the women currently in UK prisons are serving sentences for non-violent crimes. So as I mentioned, the prison population is about 88,000 in the UK. Prisons are overcrowded. I witnessed that in my 4 visits just earlier this month and late last month. What is driving this? A key factor in this growth is the trend towards longer prison sentences. So while we have this raft of legislation enabling non-custodial approaches, we also have had a tendency of judges to give long sentences. And we also have in the UK something called the Sentencing Council, which has stipulated effectively certain mandatory minimums and certain bands of sentences, which has reduced the discretion of judges. They are, in a sense, obliged to sentence within the band of what is put down by the Sentencing Council as an appropriate sentence. So overcrowding has become so serious in Britain that the departing Conservative government and the current Labour government, they've had to start releasing prisoners. Up to 10,000 prisoners released in the last couple of years. Well, that's well and good, except that it only takes 1 or 2 reoffenders to commit very serious crimes in the public eye for the government to face serious reputational risks and negative public opinion. So that's where things stand currently in the UK on prison numbers and on non-custodial. Let me turn to something around probation itself, because I was a serving probation officer working in a busy magistrates court, spent a lot of time visiting prisons and meeting people who were either recently convicted or about to be tried or about to be released. The sort of message I'd like to share with you is that ultimately the UK example I'm going to share suggests that the public sector may be a better delivery vehicle for non-custodial programs than private firms. That is to say, the public sector and, of course, paraprofessionals, faith-based institutions, and the many other voluntary associations who may be connected with non-custodial sentences. The experience from the UK suggests that private firms managing community service orders, which is what happened, actually gave poor outcomes and increased reoffending rates. One unintended consequence of all of that was that judges, magistrates, particularly in the lower courts, they began to lose confidence in the idea of a community service order. They began to think, well, what's the point? 3 out of 5 of these orders are that the person's going to reoffend, and we'll have to recall them back to prison. So fewer non-custodial sentences were being passed. It got so bad that the UK Ministry of Justice announced in 2019 that it would bring the management of all offenders back in-house, that is to say, under the rubric of the ministry. And that was a landmark decision, reversing the reforms that had started only 6 years earlier by the then Justice Secretary. His name was Chris Grayling. The wisdom after the fact is that the minister, Mr. Grayling, ignored warnings that his reforms wouldn't work. He outsourced the management of all medium and low-risk offenders in England and Wales to private companies. The private companies were going to get part of their money by meeting a target of non-reoffending. Most of them didn't meet that target. They didn't get their money. They cut back their services, which added to the pressures on reoffending, which reduced the confidence of the magistrates in giving these sentences in the first place. At the same time, the probation service, which had been around for decades and decades and decades, was itself reduced in size. It was folded into the prison service. That's okay. You want to do that, and made to just focus on the more serious crimes and the higher risk offenders. The upshot is that the failure of these reforms led to poorer services for offenders, more pressures on prisons, increasing risks to the public. One lesson, I guess, that we can draw, if you agree, perhaps we can discuss, is that something like probation or community service, it's a complex social service. It can't easily be reduced to just a contract, particularly a contract that's driven by cost cutting. Maybe the other lesson is that what happened in the UK is really a textbook case of how not to contract out social services. Well, I've spoken for about 20 minutes. Dr. Ibu Debbie, I'm very happy to take some questions or to have a little bit of interactivity. And if not, I can move on to a second 10-minute presentation on some international development programming. What would be helpful?
Okay. So we take some question first, and we continue the second session. Okay, we would like to open the floor for question and comments from the audience. Okay. You can please feel free to click the raise hand icon on your Zoom screen, so we can, yeah. We have one Dr. Siti Nafsia here, and anyone?
Ibu Debbie, excuse me.
Yeah.
I think Bapak Heru Susetio also
Raise hand?
his mic. Yeah, open his microphone.
Oh, okay. We have Ibu Dr. Siti Nafsia and Professor Heru Susetio. First, we give the floor to Prof. Heru. Prof. Heru, ya? Oke. Oh, Ibu Siti dulu. Bu Nafsia.
Siti dulu ya, Prof.
Prof
Siti dulu.
Heru aja nggak apa-apa, Prof Heru, I'm fine. I'm
Saya lagi
fine.
masih nyetir.
Oh, masih nyetir. Oke.
Iya.
So, okay, and first Dr. Nafsia.
Thank you, Prof Heru, nggak apa-apa.
Silakan, please.
Ya, hati-hati di jalan. Kalau nyetir berhenti dulu, safety
Baik,
riding.
Baru pulang pengukuhan.
Mas, serius, kok nggak ngundang?
Iya,
Lupa.
sangat terbatas.
Oh, sangat terbatas.
Sangat terbatas. 3 orang soalnya.
Oh iya, selamat sekali lagi.
Terima kasih.
Oke.
Is time mine? Oke, makasih Bu Debbie. Selamat malam semua. Assalamualaikum warahmatullahi wabarakatuh.
Salam.
I just first of all thank you very much to Pak David and Bu Devi, and of course Pak Ketua saya, Pak Ketua di IPSPI, Pak Pujono yang selalu menjadi the energy of IPSPI and APKPSI. Pak David, hello, I just want to say I am graduated from McGill University.
Oh, fantastic.
Yeah, I took my bachelor and master degree at School of Social Work, McGill University, Montreal. So I see you, so I remember everything about McGill. I miss McGill very much. Okay, I listen carefully whatever you say, and I just quick read your draft, your paper. It's excellent because I want I am a lecturer at School of Social Work at State Islamic University, UIN Syarif Hidayatullah Jakarta. So one of the subject or course that I teach for my student is social work in correctional setting. This is very interesting. Why I am also very curious to listen everything from you tonight, and from what I note from your paper is this is I think one paragraph. Social worker emerge as essential mediators between justice system and communities.
Yeah.
So Pak Tora, congratulations, Bapak Ketua. I forget to mention you. Pak Tora recently explained about some problems in Indonesia. Recently, I am also a supervisor, a lecturer for my students who are conducting field practice at what we call rumah tahanan in bahasa, in English, Bu Debbie. Detention house, right? Yeah.
Yes.
Yes. My students are conducting a field practice at the detention house, Cipinang. So I am and my students are learning very much, and we are recognizing that social work is not yet in the structure of professional. I don't know what we call dalam struktur bagan kepegawaian apa Bu Debbie. So we are not yet in the structure of professionals and board members in correctional settings. Please correct me, Pak Tora, ya. This is, I think, one of challenges for social worker in Indonesia. I am very optimistic. I always encourage my students. This is very interesting topic. This is very interesting issue and very professional career if social work who are maybe in correctional settings. So I always convince my students. But in reality, I have to like answer many people in a correctional settings, let's say in lapas or detention house or prison or correctional institution, persons who are working there asking, what is the difference between psychologists and social work? What is the difference where let's say I am giving an example. Yeah, social worker, we are one of our role is like doing counseling, like our consultation. So he is asking again to me, what is the differences between the counseling conducted by psychologists and social worker? So once again, say to me, so should we need social worker at the same time we already have psychologists? So I think one of like I don't know what we say challenges or how we explain to maybe our very hopeless to the government itself and also to the community that that we have to rise to have a very loud voice. I am social worker. We are different from psychologists. So how I think I need your enlightenment how to answer such that questions. Okay, thank you, Bu Debbie. Thank you, Pak
Thank
David.
you, Dr. Nafsia. So I give it the chance to Prof. Heru.
Yeah, well, thank you. First of all, fantastic to have this connection with McGill. Secondly, wonderful that you are doing this coursework with your students and encouraging, in a sense, the professionalization. It's a tricky one, isn't it? The demarcation between social workers, psychologists. There is overlap, inevitably. Obviously, certification helps enormously. Again, in the UK system, there is a ready-made social work entry point through probation. When I did my MSW, probation was a distinct field, but we all did the same coursework. So I was also working on, family issues, children without parents, all of those things. So we spoke a common language. There was a common certification approach, but probation was understood to be a distinct and professional service that was university-backed, understood within the prison system, understood by the community of professionals working with a defender, which may range from a judge to the police service, to the medical profession, to the mental health profession, and that the social work element was distinct and important. I suppose that part of the brief of social workers working in prisons, whether they call themselves correctional social workers or whether they call themselves probation officers, is this pivotal point between the offender, the institution, and the outside world, particularly the world of family, work, and reintegration. Some of the work I did as a probation officer was working with offenders who were maybe 2 years out from release. There were a bunch of issues to do with their family. There were a bunch of issues to do with where they would relocate themselves. There were issues to do with their emotional well-being that were maybe of a more general nature than what a psychologist might have to deal with. So, I may have been dealing with prisoners who were experiencing various forms of emotional suffering, shall we say, from depression to anxiety, but were not of a clinical nature requiring the services of a psychologist, say a psychologist who would be providing, cognitive behavioral therapies, for certain specific issues that may be substance abuse related, alcohol, mental health. So I think it's really about professionalization and providing us a unique set of services, navigating the interests of the individual and that process of reintegration back into society. How the various Indonesian associations and the universities and indeed the government ministries then recognize that and demarcate that set of skills, Indonesians will work out. But it isn't an easy one to do. But I personally am convinced it's a distinctive set of skills, and you shouldn't feel shy about advocating for that slight demarcation with the work of psychologists, which is also key. The inmate that I saw, for example, in the British prison, and I saw him on several occasions, the crime had been committed 6 years ago. He waited 5 years because of COVID for sentencing. In that time, that individual suffered a great deal of personal conflict. There were attempts at self-harm, suicide, and so on. So at the point of sentencing, there was a probation report on the table for the judge. There was also a psychiatric report. At the point of sentencing, when the offender was put in prison, he got a psychologist help for the first 3 months because of the trauma and shock of imprisonment. Following that, there has been more social work input, and particularly social group work. So they are complementary services, but distinct services. I don't know if that helps you.
Okay. Thank you, Devi.
Thank you very much. Very helpful. Thanks.
Thank you. So we go to give the turn to Prof. Heru.
Okay, thank you, Bu Debbie, and thank you so much for everyone for this opportunity, also to Pak David, also Pak Dr. Pujono, and then Ibu Siti Nafsia, and Prof. Ali Equatoria. Very happy to know all of you. Actually, I'm a newbie in. I'm not really a social worker, but I'm happy to be in social
You are
work.
professor. You are professor.
I'm not a social worker actually. My background is lawyer, more on human rights lawyer and human rights lawyer. So I'm dealing with legal aid almost every day, and I'm human rights lawyer. So I'm dealing with ABH, with children in conflict with laws, because I represent them before the court and represent them. Because most of the time, lack of proper representation from the legal side, from children in conflict with laws because they are mostly poor and have no proper support from the family and from the society. So my question is in regarding the how to prepare the community of the people, the society in the afterwards of the prison term, particularly for the children who were in conflict with law, because our problem is actually a bit complicated. Not just legal problem, but also social problem, and cultural problem, and also systemic, more on the structural problem. In terms of cultural problem, we have problem with the people, with the culture, because we have the revenge culture, or it's not that easy for the society to accept the former prisoner, to accept the former children in conflict with law. So my question, how to deal with that, how to deal with the society, how to deal with the community, even not just the common people, even the family. Many family actually doesn't want to accept their children or their member of family who were previously in prison. Even they reject them, because I did some study in the correctional center in Jakarta, and also in Balai Rehabilitasi in I think in Cilengsi, and I get information from the people over there that even the family reject them to accept the form to take them to reintegrate to the family, because they think this guy or this prison actually making same to the family, shaming the family, so they doesn't want to accept the member of family. My question: how to deal with that? Deal with the family, deal with the community, who actually not really generous, or not really welcome to their member family to reintegrate, to reintegrate to their family. Thank you for the time and opportunity, and nice to see all of you, and also Pak David. Makasih.
Thank you, Prof. Please, David.
Thank you, Professor. It's a really tough one, isn't it? Much of my work years ago was with young offenders and persuading judges not to send them to detention or prison in the first place, so youth diversion. But I do agree with you, and I can remember very vividly, for example, an Indo-British, that is to say, a British citizen of Indian origin, from a very traditional conservative Hindu family in London. The young man had got involved, but firstly, he completely rejected his culture. He started dating local English girls, got into trouble, unfortunately got involved in a robbery, was sent to prison, came out, and to an extent that the family was certainly not welcoming. And there are many cases like that, as you've touched on. The issue of stigma is very real and very daunting, I think, both for the young offender coming out of detention or prison, and indeed for any professionals working with them. One way to address this, and of course much of it is dependent on resources, is if there is serious family rejection. There are things in, say, the UK system, and I'm sure it's the same in Canada, things called halfway houses, where the state, in a sense, has provided a modicum of safety and care in a residence where there are professionals, a professional social worker or a youth worker, working with maybe 5, 6 young offenders who've come out of prison, and helping them reintegrate slowly back into society. Step one, quite often, and I'm talking about a context of a particular city, London, was to try and get them into housing. And, probation officers, social workers working in correction field, you develop your contacts, you develop your networks, 1 or 2 employers in the local area who will tolerate, consider, be pressured into, be persuaded to take on board a young man who's come out of prison after 18 months. Okay, he made a mistake in his life. He's still young. He still has a future. He still has potential. I'm not saying they're always successful, but that's one way of going about it. Of course, for us in a place like the UK, when there is family rejection, it is very difficult, and it does raise the stakes and raise the possibility of reoffending. And also, obviously, and unfortunately, if there's no future for the person, if he can't find a job, if he's got no friends, his family has rejected him, she may soon find themselves, quite frankly, on the streets, homeless, with all the pressures that that brings of further criminality, of substance abuse, of mental health issues. And then we are in the vicious circle of people going round and round and round. You know, they commit another offense, they interact with the police, they're in front of a court, they're resent to prison, and then the cycle repeats itself. And unfortunately, too many people in those prisons in the UK, they have had careers of detention where they were not, in a sense, caught early enough by caring lawyers, social workers, police, youth diversion, and ended up essentially in a life of petty criminality where they offend, they're put in prison, they're released, they reoffend. So it's a problem in Indonesia. It's certainly a problem in the UK and Canada. Thank you.
Okay. Okay, thank you. I can see
Okay,
some
thank you
questions.
so much.
Okay. Yeah, I can see some enthusiastic question on the chat box, but maybe it's good for us to continue the next 10 minutes for the explanation from David. Is it
Well,
good?
that's kind of you. Shall I, because it's become interactive, Dr. Ibu Devi, I'll just keep it to about 5 minutes. I was going to talk about 2 international development programs that were focused on young offenders, just by way of an illustration of how governments, in this case, the government of Jamaica, the government of Ukraine, reached out to international partners and co-designed an initiative to work with young offenders. I won't talk about Ukraine today, although that is very interesting from a policy point of view. I'll just briefly mention Jamaica.
Yeah. Yeah, okay. So please continue.
Okay, I'll do that. Thank you. So Jamaica, small island in the Caribbean, a lot of British connections, a colonial experience that friends and colleagues here will understand only too well. A proudly independent country for a long time. Crime and violence today, it continues to be one of the most serious threats to national security and development in Jamaica, to the integrity of the state, and to the lives of all Jamaicans. Crime is also hitting the economic bottom line in Jamaica because it is potentially threatening the tourism industry, which is a big part of the public revenues, a big part of the economy and the GDP. It's been like that for a long, long time. Jamaica's homicide rates, murder rates, have been systematically higher than the region and the global average for a long time too. The fact of the matter is, most of the perpetrators and victims of violent crimes in Jamaica are young males aged between 15 and 30. They have a pattern of weak or non-existent attachment to the labor market, to educational institutions, or to stable family environments. In the project, in 50 communities, at-risk communities that were part of the project that Canada got involved in, only 16% of the youths grew up with 2 parents. Those project communities, and I visited some in Kingston, Jamaica, in an area called Spanish Town near the docks. They have a prevalence of gangs. They have often communities with low levels of employment, low levels of educational skills, lack of access of those communities to formal justice systems. The tendency, and this is by no means a criticism, the tendency of the government of Jamaica was traditionally to favor crime control. That is to say, young offenders who got into trouble with the law, if there's violent offenses, automatic detention, prison. But they were seized, the government, with the limited impacts of a tough-on-crime approach. And the Jamaican Ministry of National Security approached international partners to support and design some community-based alternatives. So a project was developed. It was called the Citizen Security and Justice Project. It extended for over a decade. And Jamaican Ministry of Justice, Jamaican Ministry of National Security partnered with Canada, Global Affairs, with the UK, Department for International Development, and with the Regional Development Bank, the Inter-American Development Bank. What was developed was a multifaceted crime and violence prevention initiative run by the Ministry of National Security, supported financially and with a little bit of technical support from Canada, UK, IADB, the Development Bank. And they worked with 50 at-risk communities across Jamaica to design some alternatives to traditional crime control measures. There were 3 pieces to it. There was a cultural change component pitched very much at the community level. And here, social workers were integral to program delivery because they helped. It was they who helped build community resilience. It was they who did some of the assessments and referrals. It was they who provided the counseling. It was they who did the community liaison and the liaison with other professionals. So there was a cultural change component, the nub of which was to help communities live together more peacefully and to govern their own problems and to challenge some of the attitudes and change those attitudes that promote or tolerated violence. I'll talk about some examples in a moment. Second piece, labor market. This included a component that looked at workplace training, life skills. Many of the kids, many of the young men just didn't have them, to be honest. Job placement opportunities and remedial and formal education to help them get ready for the marketplace, if you will. Third component, community justice. This was managed out of the Justice Ministry, and it was to provide essentially formalized youth diversion programs away from the court systems. So a young person commits a crime, maybe is found in possession of guns and possession of drugs. Instead of being sent to court, the Ministry of Justice takes that problematique, if you will, and starts providing a set of activities and interventions within the community. So this was done, and I happened to be involved in the first phase of it, around 2010, I think it was, and it went on for about 10 or 12 years. I'm not saying it was solved all the problems in Jamaica, but the point is that international assistance had a small, modest role to play at the request, and only at the request of the government of Jamaica, to try something different. And in that sense, as jurisdictions are reaching out to see what works, what doesn't work, sometimes that international partnering can be a way to pilot new ways of addressing long-standing problems. So I'll stop there. Terima kasih. Thank you very much.
Thank you very much, Dr. Gillies, for your insightful presentation. I see some question in the chat box. Let me read one for you.
Sure.
One moment. Okay, it's from Mr. Jeremias Utun. I think it's not really a question. He said that currently there are 274,317 prisoners in Indonesia, and the prison system is operating at over 180% capacity. This situation clearly calls for an urgent government evaluation. social workers through collaboration between the Ministry of Social Affairs, the Ministry of Law and Human Rights, and a consortium of social work professionals, including research institutions, should advocate the integration of social work approaches into criminal justice reform. By adopting these approaches, communities can move toward a criminal justice response that is more effective, human, and sustainable. One of the promotes both individual rehabilitation and collective well-being. This effort should also emphasize a cost-benefit analysis, as the current overcapacity in prisons highlights the economic and social inefficiencies of continued reliance on incarceration. Maybe Mr. Jeremy Wotton want you to respond to his opinion, David. Do you have
Well, thank you for sharing those startling facts about the current prison population. I should just say, out of respect, you'll understand, I'm sure, Dr. Ibu Debbie and friends listening, I'm an outsider. I don't have Bahasa. I do not know the complexities and subtleties of the Indonesian context. So I think it would not be appropriate for me to share an opinion, a strong opinion, one way or the other. But those facts, in a sense, do speak for themselves. They speak volumes. I did mention in another jurisdiction, the UK jurisdiction, the occupancy rate was 99%. So there, the prisons are full. And I can say that the alarm bells in that jurisdiction are ringing loudly and clearly. The UK made the policy decision that the overcrowding was so problematic that they had to let some air out of the system. That is to say, release prisoners. That's the route they chose to. And that brings its own challenges too. But that's the route they have taken. I do remember just reading something from the inspector of prisons in the UK saying loud and clear that his management of the whole system of 88,000 prisoners, there are at least 8,000 to 10,000 still too many in British prisons. So that gives you a sense of the pressures on prison management, on social workers, psychologists, and prison officers who are working in those settings, on the inmates themselves. And that pressure cooker can obviously lead to challenges in the outside world if prisoners are coming out of prison not having received the right kind of rehabilitation opportunities because there's not enough resources, there are too many prisoners, there aren't enough staff, etc. So society can pay a price, and at some point it becomes a public policy issue. Shall I leave it at that?
Okay, maybe later, Mr. Jeremy Wotton would respond to this. But we have another written question, if it's okay,
Sure.
from Hanifa. And Hanifa would like to ask question, and apologies for the asking through the chat box due to network issue. She said that she asked like this: the non-custodial approaches require a true analysis of various factors contributing to recurrent criminal behavior. As social work practitioners, I'd like to understand your perspective on the challenges we should consider in addressing the issue of recidivism. Furthermore, if we aim to implement this approach, one of the main obstacles we face is the lack of comprehensive data regarding the factors that lead to repeated criminal behavior. What are your thoughts on this matter? Could it be possible for social workers to assess the conducting assessments for or research as a basis for an updated database on recurring criminal behavior factors? So,
Wow.
what's your opinion?
Thank you for that simple and straightforward question. And I wish I had a magic wand and no, I am not, I don't think, expert enough to be able to disentangle, perhaps Professor Tara at the beginning is actually better placed than me to understand, particularly in an Indonesian context. But I would say, yes, the evidence base is vital. I do think that if a jurisdiction is on the threshold of enabling legislation permitting more non-custodial approaches, parallel to that, there is the potential for universities, government ministries, professionals like social workers to be part of a shared research agenda that will gather data and demonstrate in what contexts a particular non-custodial alternative works or is facing challenges. The whole conundrum of reoffending is so complicated. I do believe the questioner who underscored, I think it was the human rights lawyer, the cultural issues about offenders being released back into society where society still has a huge stigma around criminality. I mean, think of, obviously, violent crime, sexual offenses, sorry to be so straightforward, are two of the most difficult categories. There's the whole conundrum also of what to do with so-called dangerous offenders. This is a very lively debate. There's been an election here in Canada just yesterday, and I can tell you that the party that didn't make it to government is a strong and represents a considerable part of the population that firmly believes in law and order, that is very, very much opposed to even terms like rehabilitation. For some Canadians is problematic. For some Canadians, I can only say that. It is seen as a soft on crime approach. So research is absolutely vital to show that be it a community service order, to put it alongside what are the stats saying? Has reoffending been reduced by the community service order compared to prison? If so, perhaps we should be doing more of it. Without that, we're talking wishful thinking most of the time. And I think we have to understand we're dealing with populations that are understandably preoccupied with the safety of their communities, the safety of their families, and a tough on crime approach. So the role of social workers, yes, absolutely vital. I believe social workers could play a very important role accompanying thoughtful research designs, acting as, in a sense, respondents and witnesses, providing almost anthropological context on the complexities of family situations, community situations, issues of culture and stigma, and so on. Don't be shy. I think there's so much potential there for social workers and universities to get together on that agenda.
Okay, thank you, David. Any other question, direct question from the audience? Okay, the response from Hani, I think this could be a potential direct contribution from social workers. Because because once we understand the behavioral patterns that may occur, we can provide more practical input for addressing other challenges, such as in the case of the child mentioned earlier by Pak Heru. Thank you, David. That's from Hani.
Great.
Is there any other question from the audience? Sorry, Kalista. Okay. We have Kalista here?
Yes.
Yeah, okay.
Yeah. I'm a social worker, but my main duty, my main responsibility is a counselor in National Narcotic Board. So I work in National Treatment Center for client with substance use disorder. Just want to give my perspective, maybe because it's in the setting of substance use disorder. the transformation from punishment into rehabilitation, I think it's quite, I will say that fruitful. It's quite helpful for us, for the client and also for the family, because there's a huge and significant difference between client who has a problem with substance use disorder. When we compare in the past 3 or 4 years previously, that they almost have not get any opportunity to go to treatment centers, and usually they will be sentenced into punishment rather than having an option for treatment or rehabilitation. So, well, maybe in general condition in our country, such as in jail, we need to improve more. But in the setting of substance use disorder, I think Indonesia has quite having a significant difference, and it's we quite more having more improvements for the client to have other alternative, not to being sentenced or being prisoner, but also having an option for treatment on rehabilitation. That's it. Thank you.
Okay. David, did you get the question first?
No, not so much a question, but just to thank Salam Kalista, thank you for your question and the issue around substance abuse. I didn't understand fully the Indonesian context. I'm a little better informed now you've said this. In the UK, it is possible to have substance abuse treatment within a prison facility in many instances, not in all, in many instances, but also there is something called a conditional sentence where a judge can say, I am, you're getting a prison sentence, so we're going to release you into the community on condition that you undergo a formal substance abuse program or a mental health program, whatever the issue is. And I'm not up to speed on how well that works, but it's an interesting idea, and I'm guessing that there are dedicated professional services substance treatment centers that have now a history of experience of receiving individuals who have been in conflict with the law as part of their programs. And I think it would be interesting to understand better how you would design such a program for offenders in the community. Perhaps you'll do it in the next little while.
Yes, but you have to be honest, because the condition is not well in the setting of, like Prof. Heru mentioned previously, that the main problem is the reintegration for the client, for joining into the family, and also for the community. And all of you, for all Indonesian, must be already know that we don't have BNN, or National Narcotic Board doesn't have any social work yet. So I think what Prof. Heru mentioned previously is, when maybe we can encourage ourselves to give the good practice or the evidence-based practice, that what can social worker do when someone reintegration to their family or community, and there's an impact from social worker between before and after social worker, before or after the client or the prisoner joining or having a treatment from social worker. We don't have it yet, so it's not easy for me or my friends also to give that evidence, and then also to offering that for reintegration we need social worker for our institution, for National Narcotic Board, so the family and the client and also the community or the client can reintegrate with their community and their family. So it's really I think that's one of the challenging for Indonesia. And then yeah, that's it. Thank you.
Okay, thank you, Kalista. Kalista is
very much like the way your mind works, Calista. I think you're a natural researcher, and I love it. You know, the control and experimental group. We should do it.
Actually, right now my concern is to develop the program inside the inpatient treatment center. So I'm a head of head of adolescent for head of treatment center for adolescent. So and also I develop also the program for the female. So I think maybe someday we can offer to our nation about what is the evidence based when social worker give treatment before and after, and then we can compare that. Hey, we do something. Our responsibility is give an effect. So the nation will the government also will see that as a National Narcotic Board, or maybe later on the Criminal Justice Ministry can see that social workers is needed for the nation.
Okay. Thank you, Kalista. Maybe you can always contact David, Dr. Gillis, for the next for the future plan and your enthusiasm for this issue. Okay. Actually, I also see someone just disappeared. The raise hand disappear to Ibu Lina Favorita. Do you want to ask question?
Oh, no, thank you.
Okay.
Thank you.
Okay. While we wait for the other direct question or the written question, actually, I have two questions for you, Dr. Gillis.
Sure.
Can I? Okay. First, we have the Social Welfare Law in 2009, and we have the Social Worker Law in 2019. We also have the Criminal Justice System in 2012, where all these laws is in line with the they also put forward the social protection and rehabilitation. So we already have the foundation for this, but we also aware that we have limitation on budget, on partnership, on education, let alone the stigma, the social integration. Yeah. And how do you think how to deal with it? We have all the foundation, but we still have the limitation on those on such things. That's for the first question. And the other question, as I'm also the lecturer for the social welfare science. What needs to be done and what needs to be prepared in lectures for our social welfare students to deal with the issue that you mentioned in your presentation?
Yes, thanks for those easy questions too. And actually, you're one of the nice things about this kind of conversation is I learn as much from you, probably more perhaps than I'm sharing. And part of the learning is to ask the right questions, and you're asking the right questions on limitations and where to start in terms of enabling legislation into concrete reality, a reality that is demonstrated with strong evidence, sound practice, and a degree of acceptance by the public and politicians. It's a journey. It's a work in progress, as I've tried to indicate by comparing at least one other jurisdiction. In the case of the UK, the enabling legislation on non-custodial alternatives to prison has been evolving for 50 plus years, 55 years, 60 years. Everything is there on paper. All the opportunities, restorative justice, you name it, conditional sentences, community service, probation, blah, blah, blah. The issue, as you rightly said, Dr. Ibu Debbie, is implementation, it's resources, it's public engagement, it's political will. It's a journey, it's a work in progress. It's also, unfortunately, a journey that has rises and falls. And I believe that the social work professionals and the professional associations, and it's so encouraging to hear the number of professional associations you already have in Indonesia.
Mm-hmm.
These are the contact points for the politics of making this transition to good implementation. So I suppose the little learning I've done in international development program, where I've been involved in legal and judicial reform programming, is less can be more. Less can be more. So I'm not saying piecemeal necessarily, but choose your battles, choose your issues, gather your forces in a very sharp, pointed way. You know, our interest as a community of professionals right now is on the community service order. How can we make this better understood by the police, by judges, but more often used? How can we develop the evidence base to show that social workers, community workers can make these orders successful? How do we convey that to the public through the media? So I would say less is more. Choose your battles carefully. Choose one or two or three likely successes. Sometimes we say low-hanging fruit. Choose the low-hanging fruit first. It's always good to build on success. My fear is sometimes, and I know that international partners, they get a little crazy. They get a little ambitious. In a country like Ukraine, let's completely revise the criminal justice system. Well, you know, it's a big piece of machinery. It's evolved over decades, as it clearly has in Indonesia. There are colonial elements, there are religious elements, there are common law elements. You know, it's complex. So that would be my advice. Don't be overly ambitious, but show success and go after success in a very systematic fashion. And that means, it seems to me, conversations between and activities among professional associations, universities, practicing social workers, with the, at the very least, informed tolerance of the ministries concerned, with a ready-made audience and a channel for you to demonstrate your success, you know, up the food chain within the ministries. As far as, and I'm not sure who the senior most civil servant would be in the ministry, but the equivalent of a permanent secretary, you know, I mean, it will take that kind of effort. I think we haven't really talked about the legal profession as well. They are a potential resource for you too. And again, on a very, and Indonesia is a very sophisticated, highly developed society in so many respects, but there may be opportunities to partner or have conversations with other neighboring ASEAN states, one, and possibly some, you know, international partners like an Australia or a Canada or whomever, a Scandinavia, you know, when the time comes. So that's my part one to your answer. As to how all of that gets translated into, shall we say, training systems for social workers, ooh, I have not been in the teaching profession in this particular area at all, so I suspect, Dr. Debbie, you are much better placed. But I do think this notion of obviously the challenges are in Indonesia, and Indonesia has its specificities, its cultural uniqueness. It's got to be, at the end of the day, for practicing social workers. How does this play out in my community, in my city, and so on? But I do think social work training can benefit from a little bit of comparative context. And again, drawing out evidence bases from wherever it is, the Philippines, Thailand, India, Australia, could be helpful to you and could be done in a systematic fashion so that the future social worker realizes, in a sense, their circumstances are unique, but they are not alone.
Mm.
So I'll leave it at that. I hope that's of some help.
Yeah, it's very insightful. Thank you very much. Okay. So yeah, we open to other question or
May I have one question, Mbak Devi?
okay. Dr. Anna Sakreti, please.
Yeah, good night, everyone. Pak Puji and also Mr. Gillis. Thank you for your presentation. Your presentation is very interesting, actually. And I want to inform you that actually related to this issue, especially for children in Indonesia, Indonesian government actually already have a government regulation that regulates the intervention for children conflict with the law. We also has the Child Criminal Justice System law, Sistem Peradilan Pidana Anak, we call it in Indonesia. And in this law, actually mentioned that the role of social workers in the intervention for children in the conflict with the law. It is the only law that mention about the role of social worker in this intervention, actually. And I read your paper regarding your study in in 3 countries. You said that and then you wrote that there is a framework for intervention in the research. In your research, you mentioned about empowerment perspective and then problem solving model, system ecological approach, that I'm not wrong, and then trauma informed care. Also, for your information, Pak Gilis, we have a society with a culture of stigma toward the children in the conflict of the law. Also, even though social worker already mentioned in the law that this is we already have role to intervention for children in the law, but we has not considered yet as a central profession in this issue, actually. Maybe a police or another profession is more important than social worker. But actually, our government already mentioned, or they call social worker to have a more role in this issue. And you also mentioned that in UK or in which country that the private sector actually also handling this issue. But in Indonesia, actually, this problem is still carried out by the dominant, carried out by the government as a dominant role of intervention is still carried out by the government. And there is not much role from the private sector to handling this sector, as I know. My question is, from the four existing approach that you mentioned in your paper, actually, and from the experience in these 3 countries, which approach actually is the best from your opinion? Yeah, and what is the lesson learned uh, obtained from these studies, and also from these countries, actually, especially uh, for our existing social workers, and what is the obstacles of each approach when they implement in these countries, in this and that three countries actually. That's it, Mbak Devi. Thank
Okay,
you.
thank you, Dr. Anna Sakrati. So please, Dr. Gillis.
What a challenging and sophisticated audience we have. It's,
Yeah.
you put me on the spot.
Very
No, I
challenging.
very much like your questions, and I thank you for the information you've given me. I feel I am very much a beginner to understand all the complexities of the Indonesian context, which are unique, obviously. I don't know that I don't feel that I am sufficiently immersed on a day-to-day basis with all the ins and outs of social work in a correctional context or in a criminal justice context to be able to say which is the best practice. I think what we can, in fact, I would say generally, as someone who's been involved in international development programs, when one reaches out and works with other partner governments, I try personally to avoid the term best practice. I try to use terms like effective practice or good practice. That might seem like a subtlety of language, but it is to say that ultimately the best practice is what's going to work well in your setting. And here are some things that seem to be working reasonably well in other settings. My personal bias, not based on evidence at this point, but based on hunch, based on professional working experience, is that I could see a mixed model of delivery for non-custodial in theory. In practice, I think the enabling legislation and the political will of the government may be in question because governments may feel a certain reserve and reluctance to devolve responsibility in some jurisdictions to the private sector, whether it's for profit or whether it's non-governmental, because of the stakes involved in criminality, because of problems of public safety, because of problems of public perception. I can say that in the British case, there is a philosophy in parts of Britain, which is that the state should not be doing a lot of things. Let's put it out there for a company to earn some money and provide a service. And let's put it out there for a faith-based institution to offer a family service of support to the families of prisoners. Let's do that. When I was at a prison just earlier this month in the UK, and I tried to set up my visits, it was a family service center run by a non-governmental organization that interacted with me and acted as the interface, preparing me for the visit and introducing me to the issues that I was going to confront, and also providing, in a sense, aftercare should I need it. In my case, I didn't. I was just coming in as a semi-professional. So I can see the, in theory, part of having a mixed model where the state perhaps does the lion's share of the work, but there is a role for a private company, there is a role for a faith-based organization. Making it work in practice is all about, I would suspect, the politics, the tolerance and appetite of the government concerned, and it would perhaps again be best done through piloting. Just on that final point of piloting, the case in the UK, why the private sector model blew up, in my opinion, and was a total disaster, is because the minister, and I can say this now, I am a British citizen as well as a Canadian citizen, I'm not in government, the minister was in a hurry. The minister had a problem. We have too many prisons. We are spending too much money on the probation service and on the prison service. We need to reduce our budgets. Let's give it to a private company. There were no pilot projects at all. In my view, first pilot, see what the problems are, correct, and then deliver. He went straight to delivery and he got into trouble. Right, I'll stop at that.
Okay, thank you, Dr. Gillis. Due to the time constraint, we'll take just one last question, maybe we have the Universitas Binawan here, also UMJ, maybe, or UNPAD.
Thank you, Pak Gilis. Yeah.
Okay, and we also have Poltekkes here, if you have a question. Especially we have here the Ibu Dr. Kanya, Ibu Dr. Kanya Ekasanti from Poltekkes. Dr. Kanya, Mbak Kanya, Mbak Eka Kanya. You want to ask question? Okay.
No, thank you, Ibu.
Oke, apa kabar Mbak Kanya?
Baik, terima kasih saya menyimak. Ini soalnya baru buat saya. Terima kasih.
Okay. Okay, if you have no question, no other question, as we come to the end of today's lecture, let me
Izin
share.
Bu Devi,
Oh,
izin
sorry.
maaf. Sebetulnya pas mention Bu Eka Kanya bagus kalau beliau cerita tentang pengalaman tentang ini rehab tentang anak yang kepaksa untuk pembinaan kena jaringan teroris. Itu menarik to tell to David about it.
Oke.
Ya.
Ibu Kanya,
Ya, apa kabar? Sebetulnya saya ingin kangen Bu Eka banyak pengalaman sekali di bidang ini.
terorisme ya.
Yang anak yang terpaksa terlibat atau anak yang dilibatkan atau anak yang terpaksa menjadi korban dalam pidana terorisme.
Bunda aja yang cerita, Bunda aja yang cerita.
But
nggak punya otoritas saya.
I'm sorry,
Ibu.
Bunap, we have other lecture, especially in the terrorism. Yeah, because this is a series of lecture. So, and other lecture will talk more about the terrorism. So join us for the next.
Sure.
Yeah. Then maybe then Ibu Kanya will tell more about this in the next lecture on terrorism.
Yes,
Yeah.
thank you. Yeah.
Okay. So due to the time constraint, so as we come to the end of today's lecture, let me share a brief summary of today's session. Dr. Gillis shares comparative insights to support Indonesia's move toward non-custodial sentencing. He highlights that while there's growing global recognition that incarceration is often ineffective in achieving public safety, deterrence, and rehabilitation, political shifts, public opinion, and weak implementation often hinder criminal justice reforms. The key points include, first, alternatives to prison, such as probation, community service, and restorative justice, are critical due to the high cost, limited deterrence, and negative social impacts of incarceration. Second, successful non-custodial system requires strong professional support, infrastructure, education, and systematic research. Third, political factors, misinformation, and media influence often disrupt reform efforts. Examples from UK show rising prison population, longer sentences, and the failed privatization of probation services. International project in Ukraine, you can read from the paper, and Jamaica illustrate efforts to build effective community-based justice programs focused on rehabilitation and violence prevention. Finally, Dr. Gillis stresses the legal reform is just the beginning. Sustainable success requires strong governance, professional training, public education, and consistent advocacy. That's the summary for today's lecture. I hope it covered all the lecture today. So I would like to take the moment to thank each of and everyone of your for your active participation, enthusiasm, and thoughtful engagement throughout the session. And on behalf of the organizing committee, we extend our deepest appreciation to our distinguished speaker for sharing his valuable insights, experiences, and knowledge with us. And your contribution have truly made today's discussion enriching and inspiring. Maybe Dr. Gillis, you have any specific or closing statement for this?
Thank you for the opportunity. No, I would simply like to say, Dr. Ibu Debbie, it's been such an honor and privilege to be speaking a common language with so many thoughtful practitioners, lecturers, government officials, university-based researchers. I think it's very exciting for me as an outsider to appreciate the potential that Indonesia is now embarked on. I think there are so many opportunities for you to make some of these non-custodial arrangements a living reality that will transform the way criminal justice is delivered in Indonesia and improve, most importantly, the lives of people who have run into trouble with the law and their surrounding families and communities. So I wish you great fortune on this journey you have started.
Thank you. Okay, we hope that today's lecture has provided you with the new perspectives, ideas, and connection that will be valuable for your future endeavor. Before we officially close, I would also like to thank all the staffs who have worked hard, Mbak Disha and all the teams who have worked hard behind the scenes to make this event a success. Once again, thank you for being part of today's lecture, and we look forward to seeing you again at our next lecture series, because it's a series, right? So, okay, thank you once again, Dr. Gillis, and thank you for all the participants, and have a wonderful day, and have a wonderful rest for tonight, and I hand it over to the MC. Thank you.
Thank you.
Thank you very much, Ibu Debbie, for guiding the session wonderfully. We had such a powerful and eye-opening session. Yeah. All right, Ibu Debbie, David, and everyone. Before we continue to the closing remarks, can everyone open the camera so we can have a picture of our session? Please, everyone, turn on your camera. Great, all right. So we still have around 96 participants here. And during the session, we have almost 150 participants joining. Wonderful. Thank you very much once again. All right, Kak Hani and Kak Julfa, please help me to take the picture.
Yes, Disha, stand by.
All right. Okay, everyone. Once again, please turn on your camera. We will take picture together. Okay. I will lead the process. Please give your best smile. All right. 1, 2, 3. Okay, once more. 1, 2, 3. Okay, maybe once more. More happier and cheerful, maybe the cheerful style of photo, please. All right. 1, 2, 3. Okay, thank you very much once again, Dr. David Gillis and also Ibu Debbie. Thank you very much for the fruitful discussion we had today, and thank you, David, for your generous sharing of knowledge and experience. I believe that it will be very useful for the development of social work practice in Indonesia. And what David present earlier really reminded us, the social worker, that we have the critical role in bridging systems of justice and care. All right, everyone. So I also, on behalf of the organizing committee of the International Lecture Series, we also thank Dr. Puji Pujiono, Bapak Ali Ekwatora, and all the esteemed representatives from the Ministry of Social Welfare and the Indonesian National Council of Social Welfare, and also the Indonesian Independent Association of Professional Social Workers, as well as the Specialized Association and the Provincial Chapter. Also, special thank you to the collaborating universities, to Muhammadiyah Jakarta University, to the Islamic State University of Jakarta, Binawan University, Universitas Indonesia, Ibu Debbie and team, thank you very much. And then Pajajaran University, thank you very much for the partnership in making this event possible. And also a very heartfelt thank you to all the social workers, lecturers, students, and all participants who joined us today, both on Zoom meeting and those who watching on YouTube. Thank you very much. This has been an enlightening exchange of idea, and we truly appreciate your participation. And with that, we officially close today's 8th Social Work International Lecture Series. Thank you once again for your participation and support, and we look forward to seeing you in the next International Lecture Series. We will have another topic and speaker for the next month's session.
I'm sorry, Mbak Disha. We have
Yeah.
Pak Rudy here, Dr. Rudy, as head of Aspeksi.
Yeah, hello.
Sorry,
Pak Rudy.
I forgot to mention you, Pak Rudy.
Oh, no
Hello.
problem. No problem. I'm standby to hear the discussion. Thank you, for David.
Thank you, Pak Rudy, for joining.
And
Maybe
and
you would.
also the Ibu Dr. Sari from the Universitas Indonesia, FISIP UI. Sorry, Bu Sari. Sorry, I'm sorry. I forgot to mention all the important person here.
Halo Bu Debbie, ya. It's okay.
Yeah, thank you very much, Bapak and Ibu, and also we also have a lot of lecture from Poltekkes Bandung here. Thank you very much once again, Bapak and Ibu, and we're looking forward to seeing you, to your participation in our next international lecture series, and continue this important conversation on the development of social work practice in Indonesia. All right, everyone, stay safe, stay inspired, and keep making a difference for the development of social work practice in Indonesia. Thank you very much once again. Assalamualaikum warahmatullahi wabarakatuh. Selamat malam.
Thank you.
Thank you, David.
Thank
Thank
you.
you, Bu Debbie. Thank you, Pak
Thank
Rudy.
you.
Bye.
Thank you,
David, thank you, Mbak
teman-teman
Disha.
semuanya.
Thank you.
Sampai jumpa lagi.
Ya,
Sorry,
terima kasih.
banyak yang nggak
Gina.
disebut nih, Kang Rudi, Mbak
Gak
Sar,
apa-apa, tadi menyimak.
ada Kang